Yo, what is going on, everyone in the XRP community? Guys, we're going to keep the intro incredibly short today and get right into the meat and potatoes here. Make sure do smash the likes below. This is some groundbreaking news that has come out. This is not a freaking drill. This is not a warning. This is not hype. Dude, this is the real deal. The SEC has just suffered a major defeat in the Ripple versus SEC lawsuit, and the Hinman emails must be produced. I imagine now the SEC is going to be rushing to give Ripple what they want and settle the case because the Hinman emails now must be produced. Guys, let's go ahead. Smash the freaking likes. This is going to be a big one, guys. James K. Fillon, I freaking love this guy. So glad he just got me that follow on Twitter. Breaking. This is just like, guys, this is 1 hour ago, 2 hours ago. This is hot off the press. Magistrate Judge Netburn denies the SEC's attorney-client privilege claims. The predominant purpose of the communications was not to provide legal advice. The documents must be produced. Again, let me repeat that. The Hinman emails must be produced. And James K. Fillon, do you ever hear him say the word body slam? This is serious, guys. That decision is what Black Law's dictionary defines as a body slam. Jeremy Hogan chimes in, wow, she used the H word. The H word, hypocrisy. She is calling out the SEC on the hypocrisy and the BS that they are bringing to the court. Guys, we have a whole 9-page document. We're going to read the whole thing, and we're going to get some ultra zoom on this because we need to soak up all this information like a sponge. We can use cookies to provide, protect, note, decline. All right. Sarah Netburn, United States Magistrate Judge. By letter motion, the Securities and Exchange Commission argues that the attorney-client privilege protects internal documents related to a June 14th, 2018 speech, the speech given by William Hinman, the ETH free pass speech, which was not a free pass. The SEC can still come after Ethereum. Then the director of the Division of Corporate Finance. This argument was previously raised secondarily, with the SEC primarily asserting the deliberative process privilege. The SEC's motion is denied. Background. I think this is stuff we already know, but we got to read through it just in case there's something we don't know here. The court assumes the parties' familiarity with the facts. The SEC filed this enforcement action under Section 5 of the Securities Act of 1933, alleging that defendants Brad Garlinghouse, Chris Larsen, and Ripple Labs, collectively defendants, are currently engaging in the unlawful offer or sale of securities. Even though Ethereum was an ICO and they took money from investors before the coin was even out, apparently that's not a security. That's the Ethereum Enterprise cartel for you guys. Lining up the SEC's pockets, coming after Ripple, trying to take down the XRP ledger. And the defendants, Larsen and Garlinghouse, aided and abetted Ripple's violations. As relevant here, defendants sought certain documents from the SEC to challenge the SEC's allegation that Larsen and Garlinghouse were objectively reckless in believing that XRP was not a security, and that Ripple was on fair notice that XRP was a security. Following the court's ruling on the relevancy of certain categories of documents, the SEC searched its files and raised objections to the production of certain documents on the ground that they are protected by the deliberative process privilege. That's what the SEC is always looking for. Anything they don't want to come out to the public, they always claim they have some sort of privilege to keep it private. They have been denied. After conducting an in-camera review of exemplar documents identified in Appendix A to a defendant's motion, the court granted defendant's motion to compel production of emails related to and drafts of the speech, which there are over 60 drafts of the Hinman speech, which means there was someone pulling the strings behind him. He was just the puppet, and the Ethereum Enterprise Alliance was pulling the strings, and that means that if there's 60 drafts, at some point XRP could have been mentioned in those emails. XRP could have been mentioned in the free pass speech, but because of a certain somebody, the Ethereum Enterprise cartel, they wanted XRP taken out of that. They did not want XRP to get benefit of the free pass that the Ethereum Enterprise Alliance paid for. Guys, groundbreaking stuff. The SEC then moved for reconsideration or, in the alternative, clarification of the court's order. The court denied the SEC's motion for reconsideration and clarified that the SEC was obligated to produce all emails related to or drafts of the speech, except for any communication between agency staff discussing the speech in the context of how it implicates other separate agency deliberations. The SEC now asserts that the attorney-client privilege protects production of these documents. The court heard argument on the SEC's motion on June 7, 2022, and to facilitate the court's review, subsequently permitted the SEC to submit 10 additional exemplar documents for in-camera review. Discussion, legal standard. The attorney-client privilege is one of the oldest recognized privileges for confidential communications. It protects confidential communications between client and counsel made for the purpose of obtaining or providing legal assistance. The privilege encourages attorneys and their clients to communicate fully and frankly, thereby promoting broader public interest in the observance of law and administration of justice. Because the privilege renders relevant information undiscoverable, courts apply it only when necessary to achieve its purpose. The party invoking the privilege bears the burden of establishing its applicability. Any ambiguities as to whether the essential elements have been met are construed against the party asserting the privilege. In civil litigation between a government agency and private litigants, the government's claim to the protections of the attorney-client privilege is on par with the claim of an individual or corporate entity. While the traditional rationale for the privilege applies with special force in government context, in grand jury investigation, non-disclosure impinges on open and accessible government. The competition between the values and that the privilege accommodates is therefore sharpened when the privilege is asserted by a government. When the government asserts a claim of attorney-client privilege, it must establish, 1, a communication between government counsel and their clients that, 2, was intended to be and was in fact kept confidential, and 3, was made for the purpose of obtaining or providing legal advice, which the Hinman emails was not. The government must first demonstrate an attorney-client relationship. A government agency can be a client, and agency lawyers can function as attorneys within the relationship contemplated by the privilege. Describing privileges application, the relationship between a government attorney and government official or employee. We're just getting background information at the moment. Let's skip through ahead here. Second, the communication must be confidential. In general, the privilege does not apply if the information has been or is later shared with third parties, which I believe it was. There's a lot of CCs on those emails that we have right now. But where the client is an organization, the privilege extends those communications between attorneys and all agents or employees of the organization who are authorized to act or speak for the organization in relation to the subject matter of communication. As to the third element, the key inquiry is whether the predominant purpose of the communication is to solicit or provide legal advice. Fundamentally, legal advice involves the interpretation of and application of legal principles to guide future conduct or to assess past conduct. It requires a lawyer to rely on legal education and experience to inform judgment. But when an attorney is consulted in a capacity other than as a lawyer, as for example, a policy advisor, media expert, business consultant, banker, referee, or friend, that consultation is not privileged. Okay? Talking about giving Ethereum a free pass speech, and what we're thinking here is having XRP removed from that speech. That is not legal advice. Okay? So right now, basically what Judge Neprin is doing on these first 4 pages here is literally setting the stage and laying down here is the factual evidence of freaking justice and law before she gets into it's being denied. This is essentially like, if like, you know, let's say the judge denies their motion, then doesn't give any reason, the SC is going to say, oh, okay, well, why'd you deny it? She's literally laying out multiple paragraphs of why it's being denied. The predominant purpose of a particular document, legal advice or not, may also be informed by the overall needs and objectives that animate the client's request for advice. Holding that information in Air Force documents was communicated to or by an attorney as part of a professional relationship in order to provide the Air Force with advice on the legal ramifications of its actions. All right, number 2, application. I think we're getting to the meat and potatoes here. The SEC does not dispute that the speech reflected Hinman's personal views and were explicitly not agency policy, even though Jay Clayton referred to it publicly as agency policy and many other people. Instead, the SC argues that there is a difference between the speech itself and its drafting, regardless of whether Hinman gave the speech in his personal capacity or in his personal capacity as the then director of corporation finance, as the SEC put it at oral argument. During the drafting and editing process, he and other SC staff acted in their official capacities and are therefore entitled to assert attorney-client privilege as agency employees communicating with agency counsel. The SEC characterizes this process as Hinman seeking to protect the interests of the SEC by obtaining legal advice from SC attorneys and CorpFin and other offices and divisions about the speech. Because Hinman sought legal advice in the course of his employment about legal issues subject to the SEC's purview, the documents were kept confidential. And 3, the predominant purpose of the documents was to obtain or provide legal advice. The SEC asserts that the privilege shields most of the documents from disclosure and requires that the rest be redacted. Having heard argument on this issue and reviewed the SEC's 10 exemplar documents in camera, I disagree. attorney-client relationship. There is no debate that government employees can be clients as contemplated by the attorney-client privilege, and that she's referencing a lot of past cases, like a lot of freaking sources, essentially. The core of the parties' disagreement is whether a government employee can be a client when the matter about which the employee seeks advice is not ultimately agency business. Yeah, is getting paid by Ethereum Foundation to give a free pass speech, is that agency business? Not really. That is personal conflict of interest right there. Defendants argue that Hinman is not a client of the SEC's lawyers for purposes of advice related to an outside activity such as the speech. The SEC retorts that the speech had to have been developed as part of Hinman's official duties because the SEC staff who provided edits and feedback to the speech were prohibited from using agency time and resources to provide input on purely personal errand. At oral argument, the SEC emphasized that the information Hinman received from the SEC staff while drafting and editing the speech would not have been available to him as a private citizen. It was only in the context of his employment that he was able to solicit the edits and feedback that he did. This question made it unnecessarily complicated by the SEC's litigation tactics. The SEC has distanced itself from this speech to avoid discovery and sought to preclude Hinman's deposition on the grounds that whatever he said in the speech, it had nothing to do with the SEC's position. But literally, during the speech, he said we. He did not say I think. He said we. We, the SEC. And then you have Chairman Jay Clayton out in public, like literally saying, yeah, we made the decision. Like us. But the SEC tries to argue that it's a personal thing to keep themselves out of it and to keep the agency records closed. I love this, man. The hypocrisy in arguing to the court, on the one hand, that the speech is not relevant to the market's understanding of how or whether the SEC will regulate cryptocurrency, and on the other hand, that Hinman sought and obtained legal advice from SEC counsel in drafting his speech, suggests that the SEC is adopting its litigation positions to further its desired goal and not out of faithful allegiance to the law. The court, however, need not resolve whether Hinman was a client of the SEC lawyers because the evidence establishes that the predominant purpose of the communication was not to provide legal advice. Dude, they are getting destroyed here. This almost seems like this doesn't feel like the typical court document. This feels like there's some emotion in this. Like, I feel like Judge Netburn, not saying she's like an XRP holder or something, but it really feels like there's emotion tied to this, that she's really, because what a judge has to do is be completely neutral, take facts from both sides, and really go with their gut on who's really the right person here. And it feels like there's so much emotion in this document. The law here is uncontroversial. If the predominant purpose of a communication is to solicit provide legal advice, other consideration and caveats are not severable, and the entire communication is privileged. The parties tangle on whether the at-issue documents were generated to solicit or render legal advice on for some other reason, such as policy advice or recommendations. For entries 1 to 23, the SEC argues that the documents analyze the application of securities law to digital assets, a primary legal issue, which means that the SEC staff edits and the feedback necessarily relied on legal authority like case law and statutes. For entries 24 to 58, the SEC explains that Hinman sought comment from other SEC attorneys, and the documents consist of legal advice about what to include in the speech and corresponding legal implications. Now, who he was talking about with on what to include in the speech was, the puppet master Ethereum Enterprise Alliance lining up his pockets. That's why the emails are so freaking crucial, and they are set to be released and produced. Okay. The SEC claims that CorpFin attorneys made both non-legal and limited legal edits to final drafts of the speech. Yeah, 60 freaking drafts. That sounds like whoever, paid the $15 million, whoever really funneled down the $15 million to Hinman wanted this draft perfect. Wanted it perfect to give the most benefit to Ethereum for, investor perspective, requiring that legal edits be redacted. I find that the documents did not have the predominant purpose of soliciting or providing legal advice. Privileged legal advice must be intended to guide future conduct or to assess past conduct. At oral argument, the SEC counsel argued that the speech was purely legal because it addressed the securities laws. Okay, but then it addressed the securities laws, but it was opinion. You're claiming it was opinion, but then they said it was we, and everyone's, referring to it as the SEC made a decision, but now it's... These guys make any freaking sense, man. Application to digital assets, and therefore any advice regarding the speech must have been legal advice. This argument is a tautology. I don't know what that word is, but I feel like this is a very fancy way of saying BS. Let me know in the comments below what that is. First, while the speech was primarily a statement of Hinman's views on policy and cryptocurrency regulation, it is no surprise the speech covered legal ground. After all, the SEC's work is intrinsically related to the law and its enforcement, but that does not mean that the advice given by agency lawyers was legal advice intended to assist the agency in making decisions or acting lawfully. Indeed, later in oral argument, the SEC counsel suggested that the legal advice was to educate Hinman on legal standards. If the predominant purpose of the agency lawyer's comments was to inform Hinman about the law, but not to advise the agency in its decision-making, it is not protected communication. Second, Hinman testified under oath that he circulated the draft speech to SC staff to enable him to get reactions to the content of the speech, and testified that he did not recall specifically what comments he received. Oh my God, what BS, dude. Come on. What, trying to play dumb now? In June 14, 2018, speech was intended to express my own personal views. Then why'd you say we? During the speech, you can look at it. Hinman says we, not I. He says we, the SEC, while he's working there, not I, about offers and sales of digital asset Ether. Yeah, it's so funny how they narrowed down this whole speech to one specific digital asset that they're all getting freaking their pockets stuffed by. The law is settled that policy advice, like whether it is a good idea or a bad idea to make a particular public statement as a public figure, or communication advice, like whether a statement is on mess with the agency's position, is not protected legal advice even when it's offered by lawyers. Accordingly, the predominant purpose of the communication was not to provide legal advice to aid the SEC in conducting public business. The documents must be produced. The Hinman emails must be produced. The SEC seeks to leave redact portions of entries 29 and 35. The SEC shall submit the two proposed redactions for the court's in-camera review. Conclusion: the SEC's motion is denied. Consistent with the court's April 11, 2022 order, the SEC shall submit two proposed redactions in entries 29 and 35 for the court's in-camera review. So ordered. Guys, the Hinman emails will be produced. Major defeat today for the SEC, guys. Thanks so much for seeing the video today. This is getting me hyped. I am sure we're going to see probably a little more price action on XRP. And honestly, if we could get the SEC lawsuit settled and Jed McCaleb at 0XRP, the parasite gone, dude, we are priming ourselves to start the path to $1.95 XRP. Guys, make sure you like the video, subscribe, leave a comment down below. This is breaking news, guys. So glad to share this with you today. I know we read through this freaking thing like crazy, but we went through it really fast, but I did not want to make this like a 30, 40-minute long video. But guys, thank you for tuning in. This is awesome. Major win for Ripple. This is breaking news from Alex Cobb. I'll see you guys in the next one.